Can you settle your medical malpractice case shortly after starting it and before depositions take place? Would you like to learn the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is yes, it is possible. The longer answer is, does it happen often? The answer is, no, it doesn't. So let me tell you what I mean. You believe your doctor was careless and caused you significant harm and injury. Your doctor denies all of your allegations. He refuses to accept responsibility for what occurred to you. And now you have no choice but to seek out an attorney to see whether or not you have a valid medical malpractice case. Your attorney has to evaluate and investigate your particular case, which takes a number of months, and he has to have a medical expert confirm that yes, your doctor violated the basic standards of care, which caused you harm and injury, and that your injuries are significant and permanent. Once you do have a valid case, now your attorney can go forward and start a lawsuit on your behalf. When your attorney tells you that he's starting a lawsuit on your behalf, you tell him, listen, I know I need to bring a lawsuit to obtain money as a form of compensation to get repaid for all of the harms and losses and damages that you incurred. However, you also tell him, listen, I don't have the ability, I don't have the time or the desire to go through the entire litigation process. I don't want to go all the way to trial. I don't want my case to take 2 or 3 years. The moment you have the opportunity to settle my case, I want you to settle it. And your attorney is telling you, listen, that's not a great strategy, because at the very beginning of the case, the defense, the people whom you have sued, will not know all the details and all the facts of your case. Your injuries will not be complete, meaning you will not know the full extent of your injuries at the very beginning when you start your case, because you are still undergoing medical care and treatment to fix the problem that was caused by this careless doctor. So your attorney is telling you straight out, I would wait. You have to go through the process to allow the injuries to develop, to see what permanent injuries you have, and also give the defense an opportunity to learn exactly what was done wrong and what injuries you have. Now, you turn around again and you say, listen, I am not going to go through the whole litigation process. If you can, I want you to settle this case before I have to give my deposition. In case you don't know, a deposition is a question and answer session that's given under oath, and in pre-COVID times would take place in your attorney's conference room. During COVID times, it typically takes place on a Zoom video call. Okay, so now you don't want to have to spend the time and energy to prepare for a deposition and to go ahead and be asked hundreds and hundreds of questions during the course of this day-long adventure where the attorney gets to probe and to ask hundreds and thousands of questions all about what happened to you and why. So based on your instructions, your attorney reaches out to the defense, and now they start to negotiate. But there's a problem, and you might be thinking, what could the problem be? Well, the problem is that they're somewhat operating blindly, meaning the defense doesn't have all of your medical records yet. You see, when you came to your attorney had many months in which to obtain all of your records. And then he had a number of months in which to have a qualified medical expert review all of those records in order to give your attorney an educated answer about whether or not you had a valid case. The moment you start your lawsuit, the defense is already behind the 8 ball, which means they now have to have the opportunity to get copies of your medical records. And the way to do that is we provide them with copies of your records, and we also give them permission slips so that they can get copies of your records directly from the doctor's office. Because they have this saying called trust but verify. So yeah, they'll take our records and look at them, but they want to make sure that what those records really say is what the doctor really said. In order for them to gather all your medical records, it will take many months. And by that time, your deposition will likely already be scheduled. And that means that you are going to have to answer questions by the defense attorney in order to go ahead and inform them and educate them about exactly what happened to you and what your recollection, your memory of the events were. Now, you turn around and say to your attorney, I don't want to go forward with a deposition. Settle my damn case, get rid of it, move it along. One of the big inherent problems with doing that is that whatever offer comes in is likely going to be a lowball settlement offer, because the defense will know that you and your attorney are desperate to get out of this case. And if they offer something called nuisance value, which means something very, very small, there is the possibility, based upon your eagerness to settle your case, that they can settle it for a very, very small amount. Now, if that's your intention, if that's what you want to do, and your attorney goes along with it, God bless you, and that's great. And then you will have resolved your particular case. However, most attorneys worth their salt are going to advise you that this is not something that they recommend, because the defense will know that you are desperate to settle your case. And the moment they sense any desperation, the moment they recognize that you are quick and eager to get out of this case, they might just take you up on your offer. And they might give you some lowball settlement offer, which, in this case, you might just accept, and then this case would go away. So why do I share this quick information with you? I share it with you just to give you a sense of what could happen if you are desperate and eager to try and resolve your case, and you know at the outset that you have no desire and no real intention to carry through till the end of the litigation, because it's just not something you want to go through. That's something that you need to be aware of. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.